A justice of the Superior Court or a chairman of a regional tribunal shall not be removed from office except for stated misbehavior, or incompetence, or on grounds of inability to perform the functions of his office arising from infirmity of body or mind. Article 146, the now famous Article 146, Clause 1 of the 1992 Constitution. What is stated misbehavior? The reason for which the Chief Justice, Justice Araba Isaba Sakitokonu, has been removed from office. The reason for which Charlotte Osei, chairperson of the Electoral Commission, was removed from office. The reason for which her two deputies lost their jobs. Same reason Loretta Lamte, chairperson of Shraj, was removed from office. The reason for which a deputy of the NCCE was removed from office. The very first time Article 146 was invoked since the 1992 Constitution. I'm Samson Ladia Yenini. This is the law. It's your legal light. It is your help law. Be right back. You're welcome back. This is the law. It's your legal light. It is your help law. It's been a week where there's been a lot of debate and discussion because the week commenced with the news and the announcement through a release from the spokesperson for the president and the man in charge of government communication, Felix Fosu Kwachi, issuing Kwachi Ofosu, issuing a statement and saying and telling the whole nation that her leadership, the Chief Justice Gertrude Tokonu, had been removed from office. And that followed a submission of the report by the investigative committee set up under Article 146 by the President to investigate 3 separate complaints or petitions that had been submitted to the office of the President for the removal of the Chief Justice. The petitions were submitted to the President. After that, there was the Council of State that determined what is known as the prima facie case. And then after that, the 5-member committee was formed. It was followed by suspension of the Chief Justice. The committee eventually submitted its recommendations, and the President, by law, is bound to act on the recommendations, and the President acted on the recommendations to remove the Chief Justice from office. The committee took some 133 days since April 22, 2025 to deal with the subject matter. The members were Justice Poaman, who was chair, Justice of the Supreme Court, Justice Dibu Asiedu, also a Justice of the Supreme Court, he was a member, Daniel Domelevo, former Auditor General, Major Flora Dalugu, who is from the Armed Forces, and Professor James Jisa, Associate Professor at the University of Ghana. And as we know, there were at least some 6 suits that were filed seeking to challenge the process. The petitioners were Daniel Ofori, and there was one petition by a group known as the Shining Stars that was very controversial. There was Ayamga Yakubu, a police officer who also submitted a petition. You had the petition of Daniel Ofori, containing as many as 21 allegations of misbehavior and 4 allegations of incompetence against the Chief Justice. So this is where we are now. So now let's get to appreciate when the committee concluded its, work, and as we have become aware, they have stated that the Chief Justice, her conduct in respect of some of the complaints were found to constitute stated misbehavior, and that's why she was removed. So that's why we are asking this afternoon, what is that animal known as stated misbehavior? Joining me is lawyer Cole Abaka Asuman. He's now in private practice. He was in private practice and then went into public service, becoming the youngest to become the legal counsel to the President of the Republic, Nana Addo Dankwa Akufo-Addo. He had the rare privilege of, seeing some of these things as firsthand and dealing with them in that respect. So let's hope that he's able to assist us appreciate what stated misbehavior is. Cole, thank you so very much for making time to join us this afternoon. Please,
thank you very much, Thompson.
Great to have you. Great to have you. So yesterday I was on Newsfile interviewing a number of people, including experts, including former ambassador, former attorney general Ayikwe Otu, who was also lead counsel for the former Chief Justice, Justice Gertrude Torkornoo, and he asked one question: where in the law is stated misbehavior defined? Have you also had to, as it were, ask yourself that question?
Oh, yes. If the stated misbehavior was defined in law, it would have made a lot, it would have made, our work very easy as lawyers. But unfortunately, we don't have it defined exactly is stated misbehavior. So in times past, what we've had to rely on was, what the categorized as stated misbehavior, and this is not exhaustive. The list keeps expanding as these cases keep coming up, and the threshold for what constitutes stated misbehavior, then depending on how you look at it, getting dropped or getting increased. If we had it defined in law, it would have really been beneficial to us. But we, Ghana being a common law jurisdiction, we can rely on what the courts have been saying and what they have said. I must say that no particular case has actually defined what amounts to stated misbehavior. We've been given clues in some of the cases, and I'm sure in the conversation sort of make reference to some of the cases, but there isn't a court case that has actually haven't had the benefit of some of these or what do you call it, these committees that have sat on these matters. We haven't had the benefit of stated misbehavior in those cases, where we're set in how they determined that those who against whom petitions had been leveled, how they fell below that standard to the extent that it warranted their removal or suspension or whatever anything, specifically stated. So I mean, you have to go to, legal dictionaries, or you've got to go to um, the normal dictionaries to understand what first of all behavior is, and then what amounts to misbehavior, and then what do we mean when we say something, or we say that a conduct or an action, is stated misbehavior, and how do you found an entire petition to remove, an office holder on that basis.
Right. So it said that constitutions contain the broad strokes of, the law, particularly to establish institutions and to give them power to exercise. Is it really fair to be expecting that the Constitution would have defined what stated misbehavior is? The Constitution uses several words, including Latin expressions, but it doesn't define them.
Yes, the question as to whether it would have been fair for stated misbehavior to be defined in the Constitution, I think, given the broad nature and how as human beings and how as practitioners we can define it as we go along, I think it would have been very helpful if the Constitution actually defined what stated misbehavior is, particularly because it is used, in the case of the removal of constitutional office holders, particularly with the Chief Justice, who heads the judicial, that is independence. They are sort of like the custodians of the Constitution. They are the ones who should not be influenced. They are the ones who should be seen to be exercising, administering justice on behalf of the people. They're the ones who hold the scale between the people and the state, and that includes the executive, that includes the legislature. And so for the ground upon which they have defined it, it should have been specifically defined, and it could have been expanded in case law. But leaving the definition open like that lends itself to all kinds of interpretations, and applications and misapplications and misinterpretations, which can result in a number of things, including the removal of office holders under the Constitution. So, if you ask me, I'd say that in my opinion, the stated misbehavior should have been defined in the Constitution. At least we should have had exactly what the definition is, and then leave the list in terms of the conduct as to what it amounts to maybe case law to determine.
Right. Now, apart from Article 146, Clause 1, we also find that in Article 151, removal of judicial officers, the Constitution employs the same, as it were, measure or the same standard. Article 151, Clause 1 says a person holding a judicial office may be removed from office by the Chief Justice on grounds only of stated misbehavior, incompetence, or inability to perform his functions arising from infirmity of body or mind, and upon a resolution supported by the votes of not less than 2/3 of all the members of the Judicial Council. So, why do you think the framers of the Constitution use stated misbehavior not only once in the Constitution and yet didn't feel the need to define it?
Well, I can't sort of guess as to why they wouldn't have done that. The Constitution is a living document. It continues to evolve. It has evolved since '92, and the manner in which we sort of interpret the Constitution, or the manner in which we apply the provisions of the Constitution, has evolved over time. And we can see it in case law and the way we conduct our governance in Ghana. And so I can't, understand why they wouldn't have done that. I can't explain or I can't attribute any reason to why they didn't do that. But what I think would have helped in the judiciary and the independent constitutional bodies, those whose removal or sanctions are tied to 146, I think it would have been beneficial if the Constitution had actually defined what stated misbehavior is. And by define, it could have just been one clause. You didn't have to give us an exhaustive list of what kind of conduct or action amounts to stated misbehavior. It could have just been one clause. Like, for instance, stated misbehavior should be conduct or an action that falls below a certain standard or falls below which is required of the office that the person holds, or falls below maybe conduct that has been specified in the terms and conditions of the person's office, or brings their office into disrepute, or affects the integrity of the office, or the way the public sees the office, or something. But then it should be clearly defined, and that when we say what stated misbehavior is, that misbehavior that is being complained of actually has to be stated in clarity. It should be very clear. It should be in writing. It should be supported by the necessary facts, and provided as well. So, I mean, this for something as very serious as, i.e., the head of the third arm of government. I would expect that a petition that is alleging stated misbehavior should specify, very clear, this behavior is what we're complaining of, that the chief justice should be removed,
Right.
Or the office would have the facts that support the conduct. And in some cases you must have the evidence, because facts can be made up. Facts can be, misrepresented. Facts can be written in a skewed way, and especially so because there is a precondition before you is, so that whoever takes those documents can know that that, okay, this is the allegation, these are the facts, and the facts are not just made up. There's evidence, or there's something that supports these facts, and for that reason, we can make that prima facie determination or preliminary determination before we proceed.
Why?
So I think that the Constitution could have done that, and could have created a framework so that we know that this is the framework that we're operating with.
Why do you think that since the 1992 Constitution was made and several people have gone through this process by the use of Article 146, they have been removed from office? 6 or 7 years after the Constitution was promulgated, the first person to suffer under Article 146 was Dr. Jacob Emmanuel Opong, who was the then Deputy Chairman of the National Commission for Civic Education. On the 28th of August 1999, he suffered. He was removed from office. He had just been appointed how many years back? He was appointed on the 6th of July 1993 as the first deputy chairperson of that important institution. Then we came to 2015, thereabout, Loretta Lamte of Shraj, then Charlotte Osei and the two deputies in 2017-18, and then here we are with the Chief Justice, a Chief Justice going through the same thing. Why do you think up to now we have not thought of the need to provide such a definition?
Samson, up to now, there are a number of provisions in the Constitution the Supreme Court has said severally, for instance, Article 181 plus 5 in the Balkan case, severally that there should be legislation,
Yeah.
about the code of conduct provision, there should be legislation.
Mm.
Look how long it took right to information to get into legislation. And so I think that, over the years, as the society, as Ghana, as the constitution evolves and we see that, listen, some of these things cannot exist without further clarity as to exactly what is required in those circumstances. And you see, Article 146 itself, the procedure with respect to the Chief Justice has evolved over the years. And I mean, practically, the petition, the process under Article 146 has also evolved practically. So, for instance, in the past, people were not given an opportunity to maybe respond at the prima facie stage. But through case law, we've learned that you cannot make a prima facie determination until the person against whom this thing is, or against whom the petition is lodged, has had an opportunity to be heard. Practically it didn't exist, but it has been built into the process by virtue of the case law. In the case of the CJ, the Ejechum case where that about, went out to give a purposive interpretation to Article 146. He read into the law. So as we're going forward, the Supreme Court is sort of dropping hints as to some of the problems that are with Article 146 and giving legal solutions to those problems to enable us have a more robust procedure under Article 146, for which, any petition must be subjected to in terms of whether the process is correct, whether the entire the petition is founded on proper grounds and so on and so forth. So I won't fault us as Ghanaians because there are a lot of things in the constitution that need correction or need to be, I wouldn't say correction, need to be updated, to meet the modern Ghanaian society. Some of these points I make in my upcoming book, about governance and law in Ghana, that, there are certain aspects of the Constitution that we need to, take a critical look at and see how, over the years, the courts have applied, those provisions and what the courts have read into those provisions as the spirit of the Constitution with respect to those articles, and see how we can, make it better or something of that sort.
Right. Now, as far back as Ejechum, you mentioned a while ago, in 2005, and thanks to Nana Asantibede and the rest of them who mounted this suit in the court, and that got us some precedents to rely on. Now, I think Ejechum is overbeating, isn't it? So Akuffo took pains, as you mentioned.
It has become a locus classicus.
Yes. She took time to instruct that we needed to pass a legislation that will flesh out Article 146 properly, because it was such a terse provision and it wasn't helpful. 2005, here we are, 2025. What do you think is going on with us?
20 years later.
What?
Yes, 20 years later. No, I think that 20 years later we should by now have some provisions, some legislation to actually guide the manner in which Article 146 is applied. I totally agree with you on that point, and that we have learned a lot. But in fact, that particular article, Article 146, and the procedure, under it is still evolving. And because 2015, the dairy case also came and dealt with aspects that the 2005, case didn't. Felt that so 2005, 2015, and now we're in 2025. I felt that the Supreme Court, in the recent CJ's case, could have also taken it a step further, to sort of get involved in constitution, was about with respect to the removal of the CJ, because the provision on the CJ is very terse, very about one or two provisions that deal with her, would deal with that office when it comes to the removal. And I felt that if for the first decade we had Ejechu, the second decade we've had Derry, hopefully in the third decade we would have had something on this matter. But the Supreme Court did not rise to the occasion, and the opportunity is gone. Maybe not, because there are still legal options available to Chief Justice Tokono.
Right. And so because the law program,
and how,
because this law show is purely for education, as we call it, is our legal clinic, let me quickly share with our viewers what Justice Sophia Kufu said in the Ejechum case in 2005, 2006, when that matter came up. This is what she had to say. Quote, "I wish to express my misgivings and discomfiture arising from the absence of any consequential enactment." She's talking about a legislative, kind of instrument or an act or some rules to guide the way we approach and use Article 146. So she says she's expressing her misgivings and discomfiture arising from the absence of any consequential enactment which regulates the removal of justices of the Superior Court, and in particular, any detailed rules of procedure for the performance of such an important process as the removal of the Chief Justice of the nation. The provisions of Article 146 sketch out in broad strokes the basic procedures for the commencing and carrying out the process for the removal of justices of the Superior Courts and the Chief Justice. And as aptly noted by my brother, Professor Okran, Professor Modibo Okran, he was also on the bench or on the panel. In his concurring opinion hearing, essential details such as the form of the petition have been left out. Also left vague and unclear are other essential matters such as the procedure to be followed by the committee in the performance of its assignment. This is only as may be expected, since a constitution is not intended to provide details and procedural guidelines, but rather to establish a framework of the fundamental values and standards upon which substantive and procedural legislation may be and are expected to be built for the good governance of the Republic of Ghana. Furthermore, it is true that unless otherwise prescribed, committees have the power to establish their own operating procedures. However, the committee envisaged by Article 146 is clearly an ad hoc nature, and it will be extremely detrimental to the nation to hold that it is up to each such committee at any given time to map out its own procedures. I seriously doubt that the drafters of our Constitution intended any such thing. Moreover, even the nature of the offenses for which a justice of the Superior Court or the Chief Justice may be impeached and removed is rather nebulously expressed in the Constitution. As they stand, the formulation of these offenses leave too much room for personal opinion and individual proclivity. For example, what is stated misbehavior? So this question was even asked by the Supreme Court itself in 2005 in a JHUM. What is the standard behavior, the violation of which amounts to misbehavior? Surely, it was expected that requisite legislation and instruments would be enacted, giving more flesh, depth, and precision to the sketchy outline drawn by the Constitution, so as to ensure that the impeachment process will have integrity and transparency. She says more, but let me pause here. We are now going to go into what exactly is stated misbehavior in the absence of a clear definition. Cole, what is it?
Yes. So, Samson, I mean, I would just add that I totally agree with her leadership, Christopher Kufu, on the points that she has made. She made in 2005. And indeed, we should have had this framework, maybe by virtue of a constitutional instrument or an act of parliament, because, like the procedure that we need to be able to conduct such matters. And mind you, there were other the justices of the Supreme Court against whom petitions have been, brought and have been removed, and also others who, were not removed. And when you sit where I sat some years ago, some months ago, where you had to be advising the president on petitions that come. Some of the petitions, I'm merely looking at it, it doesn't make any sense, respectfully. And, there has to be a way that, there's some form of legislation that determines how, the president deals with these these petitions when they come. How the committee, their rules of evidence, their rules of procedure. Because, for instance, in commissions of inquiries, because we didn't have those, we didn't have rules with respect to how commissions of inquiries are run. There was a CI that was passed some years ago.
Right. 2010.
To enable or help, yes, 2010, which guided, how commissions of inquiry, their procedure worked. So, I think that going forward, based on what she said, I think that she was speaking into the future, and we should have taken a cue from it, earlier on, so that we could have dealt with some of these petitions that came. But then, going back to the question that you
just hold on. Let me actually complete that particular quotation.
All right.
And for those of you, and you see, in this country, too often we get into the partisanship in a way that is not helpful. For those of you who think Sophia Kufu is only talking today about the need to change this to provide a detailed procedure, at least you are being informed that as far back as 2005, this is Sophia Kufu speaking in the court when a similar case was brought. And she said the Constitution's provision in Article 146 is too terse and we need to flesh it out in detail. She actually took pains to say we must define stated misbehavior. What kind of conduct is caught by stated misbehavior? Now, I need to read this small portion left out of it for you to appreciate the pain she went through in stating all of this. And she said, in my respectful opinion, just as Article 126 to 142 formed the basis for the development and enactment of the Courts Act, 1993, and the procedural rules of the various courts, which flesh out in greater detail what is merely sketched out in the articles of the Constitution. So too is there the need for the detailed enactment and instruments that will give life and substance to Articles 145 to 146, and indeed the rest of the articles in Chapter 11. Constitutionality is all right, but for a constitution to become a truly living instrument of national governance, which in terms of the preamble to the 1992 Constitution secures, quote, for ourselves and posterity the blessings of liberty, equality of opportunity and prosperity, end quote. There is also the needed constitutionalism, whereby the constitutional provisions are fleshed out in enactments that give life and real meaning to the framework provided by the Constitution. Legislative lethargy does not inure to the advancement of constitutional democracy and is indeed very dangerous in the long run, end quote. Yes, Cole, let's go. What is stated misbehavior?
Yes, so stated misbehavior essentially is, I think, is the requirement that has, the ground upon which an officer whose office is tied to Article 146 may be removed. So that we're talking about like justices of the superior courts, and like you mentioned, judicial officers.
Oh, did I lose call there? Yeah, his line is getting a little bad.
Can you hear me?
Yes. Please go back to the point you started to make.
Okay, let me just go back. So I was saying that, stated misbehavior requires that, there has to be some sort of misbehavior. There has to be, a certain conduct that falls below, a standard. And it relates to, persons whose offices are tied to Article 146. So we're talking about, justice of the superior courts, judicial officers, the EC chair and deputies, the NCC chair and deputies, the SHRAJ, and so on and so forth. But what is important is that, when the petition, the ground in the petition comes, it means that you must state the misbehavior, and misbehavior really has not been defined, and for us to be able to know exactly what it is. But from the cases, you can have some clues or some sort of leeway as counsel when you're doing that.
So can I ask
misbehavior which raises.
Can I ask a direct question then? If someone who is subject to Article 146, if they breach a law, say they have breached procurement law, or they have breached a policy, as Chief Justice Gertrude Tokonu was held to, is that stated misbehavior? Because that has become the tone, the argument.
You really have to look at it very carefully. What is the gravity of the, what is a kid? I mean, was it intentional? Was it repetitive? Were there, ways to avoid the breach that was discarded? What are the internal controls that exist within the system that ensures that breach could not have occurred? What steps were taken to remedy that breach when it was brought to the attention? So it demands you should be found. You have misconducted yourself. I mean, if you were to approach it in that manner, then many people who are holding offices, not even just public offices, private offices, would be fired every day. But it has office holders, and more especially for someone that head of the third arm of government. And I keep stressing on that because, independent arm of government and holds the scale, between like the it must be.
Okay, your line is breaking again, but can you hear me now? Hello, Cole.
I can hear you. Yes.
Right.
Where did I get to?
So let me ask.
Where did I get to? I can hear you.
Yes. Let me ask a direct question again. Let me ask a direct question again. If an officer who is liable to Article 146 breaches the Rent Act, will that constitute misbehavior, stated misbehavior, for which they should be removed from office?
Is the Rent Act linked to their office? What is the gravity of the breach of the Rent Act? To what extent is the breach? Was it repetitive? Like, was the attention drawn to it? That, for instance, this act that you applied, you misapplied it, or you breached it, or were supposed to do this or that, and the person ignored it and still went ahead and did whatever they wanted to do. All those things need to be taken into consideration for it to become misbehavior to the level for which they can be removed.
Okay.
That's what I'm saying. That
if somebody breaches, if somebody who is liable to the Article 146 breaches, say, the Procurement Act, or breaches any of our criminal offences, our criminal laws, will that constitute stated misbehavior?
So you see, for breach of the Procurement Act and breaching of the criminal law, is in a whole different matter. Criminality, for an office holder is a whole different matter. It doesn't raise civil liability, it raises criminal liability, and criminal liability is in a whole different square, which means that you could be prosecuted for it. You are definitely bringing the office into disrepute because it's criminal. And in some cases, most of the officers whose disciplinary measures are tied to Article 146, you can't hold those officers if you've been convicted, or you've been, you've been convicted for a crime, which affects your moral turpitude. And so that in itself is in a different category, because even in the JH room, the point was being made that administrative acts cannot be cannot be stated misbehavior, cannot be misbehavior, and that it was only criminality that could be. But the court held that no, administrative acts could be, which presupposes that criminality obviously is misbehavior.
Right.
So
if I may ask again and bring in directly what has just happened, one of the grounds that the committee says it found and held Justice Tokonu liable is the travel policy. There's a travel policy 2019 by the Judicial Service, which is for Superior Court judges. And that's what she says she relied on for her travel. Now, the petitioner's argument was that that travel policy does not allow you to travel with your husband, it does not allow you to travel with your daughter, and to have the state foot the bill for their, travel. Because that travel policy says, if you have to do a foreign travel, you do it with your security alone. And the word is alone. So once you did it with your husband, with your daughter, and you made the state to pay for it and pay per diems, you have violated the travel policy. And then they argue to a different level to say, even that travel policy, you as the head of the judiciary, you are Article 71 office holder. Article 71 office holders, your benefits should not be determined by some policy somewhere, because we know that Parliament determines the benefits for the President, and the President determines the benefit for Parliament and all the others. So for as long as what you used was not determined by the President, first, it was unlawful, and second, it's unconstitutional. Do you think that qualifies as stated misbehavior?
You know something, I think that, I haven't seen the petitions. I haven't seen, the record of proceedings. I haven't seen the extent to which the committee, analyzed all the information before them and then came to a decision. Which is why last week when the president put it out, I made a call to the president, hoping that he would, heed my call in the interest of transparency and accountability to put out the entire record, because not only does it, help us to understand what is going on, or not only does it meet the transparency and accountability threshold in governance, it also helps us to understand what actually went on. And it will also help in shaping how matters under that article are dealt with. It will help us to understand what amounted to misbehavior, and we wouldn't have these conflicting sort of definitions or arguments about whether this policy should have applied or it should have been Article 71 and so on and so forth. It's important for the record to be made available because, after Derry and Attorney General, it became very clear that, the constitutional injunction comes to an end. And in light of the RTI Act, these things should be made available for us to be able to, know clearly exactly what we're speaking about and what we're speaking to. In the absence of that, it's very difficult to sort of profile an opinion as to whether the policy, met the misbehavior threshold. But from what I can say, from what I have heard in the public domain, and if the conversation that have happened, I think it was so trivial. Something as a travel policy be a basis. Then there are many public officials who should not even be holding offices. If that alone is what can arise the level of misbehavior, I can bet you the number of people will fall short of it. We don't have anybody working in the public service.
In the United States, a judge of the United States District Court for the Southern District of Mississippi, Judge Nixon, was said to be required to uphold the integrity of the judiciary to avoid impropriety and the appearance of impropriety. And he was supposed to obey the laws of the United States. He had done something which they had held that had raised substantial doubt as to his judicial integrity and undermined confidence in the integrity and impartiality of the judiciary. And they said he had betrayed the trust of the people of the United States. He had disobeyed the laws of the United States and had brought disrepute to the federal courts. You know what he did? He was caught to have told a lie, as in committing perjury, telling untruth under oath. Do you think that doesn't give us an idea what stated misbehavior is?
Oh, it absolutely does. Telling a lie, for a judge to be telling a lie under oath, like I said, perjury is criminal. So, absolutely does. It's like lawyers. When, a lawyer, you go to courts and, you lie on behalf of your client. That is not part of the noble profession. That is grounds for your license to be revoked if you tell a lie. If you fill a form,
but it can be an oversight. You sign a document and say, oh, you believe everything in it is true, and then it's later found that something there is inaccurate, it's not true. That is perjury. It could be an oversight.
No, it can't be an oversight because you are making an oath. And I think that, for someone like a lawyer or a judge, where you know the consequences thereof, you should not just sign anything and blame it as an oversight.
So our judges
at that level, not even as a lawyer, as a judge, at that level, it's so high that you.
The major qualification for a judge,
so
the major qualification for the appointment of a judge is high moral character and proving integrity. High moral character and proving integrity. That's what you need to prove before you can become a judge, apart from the number of years and everything. And this is the provision. The provision is about judges. So if there's a policy and you are held to have breached the policy, will you say that is still high moral character and proving integrity?
Whether or not the policy was breached in the first place, for that to happen. But if we're speaking hypothetically, breach of a policy, for instance, it can be a policy that you should show up to work at 9 a.m., and you show up at 9:30. That would be a breach of the policy of, punctuality in the firm or in the company. But would that be a basis for you to be sacked? If you do it once, maybe not. But if it's repetitive, you're supposed to show up at 9 a.m. and you keep showing up at 10 a.m., it's repetitive and you've been warned, you've been told, hey, if you do this again, you'll be sanctioned, and you still don't care and you continue doing it. That would be a ground for you to be fired. And so if, it's important, with respect to it, like what was the testimony, hold on for me briefly.
Hold on for me briefly. Let me show you what Justice Georgina Wood defines as stated misbehavior. Justice Georgina Wood says, any moral turpitude, decadence, grave lapses of judgment, and the like in the performance of their functions of office, for example, may be classified as misbehavior. Moral turpitude, decadence, grave lapse of judgment, and the like, she says, will be stated misbehavior. And this, from Georgina Wood, came from the Loretta Lamte case, the prima facie determination that she made. This was a quotation that she gave. She said, stated misbehavior has not been defined, but from looking at all the laws, this is what she could find to encompass the definition stated misbehavior. If we check the Black Laws Dictionary, it also gives us what stated misbehavior will be. The 8th edition defines stated misbehavior as being something that's referable or synonymous with misconduct. And it defines stated misbehavior the same as a dereliction of duty, unlawful or improper behavior. Unlawful or improper behavior. It then proceeds to define official misconduct as a public officer's corrupt violation of assigned duties by malfeasance, misfeasance, or nonfeasance. Now, let's hear, it says a few other things. Now, let's hear former Attorney General Godfred Dame, what his view generally of stated misbehavior will be.
Article 45 paragraph F of the Constitution, simply the Electoral Commissioner shall perform such functions as may be prescribed by law. The Procurement Act is one of such laws of Ghana, and therefore he or she is necessarily required to uphold those provisions. And therefore, when he or she falls foul of the provisions of the Act, clearly is a very serious matter which should ground an application for his or her removal from office, as the case may be. It is very important to note that the Procurement Act itself stipulates that a breach of any of the provisions of the Act constitutes an offence. The punishment for such a breach is imprisonment of up to 5 years in prison. So how can one reasonably contend that an act which is done, which can land a person in jail, is not good enough to ground a removal from office of that person? I think that the procurement, the Electoral Commission is a very important institution of state, and the functions imposed on it by the Constitution.
So if we are to go by the definitions you are attempting to give, do you think any officer at all will be caught by this provision? Because line is frozen. Okay.
And to narrow down the definition as per the case law. Can you hear me?
Yes, we have just a minute left. Go ahead.
Okay, so I mean, I just wanted to say that, you know, for judges, one of the things that we could look at is, you know, the code of conduct for judges to determine what could amount to misbehavior. There's a code of conduct for judges in Ghana. Conduct that could potentially amount to misbehavior. So, you know, once you find that, okay, maybe a judge is acting a certain way, you want to look at it, you can look at that code of conduct first, you know, to see whether it falls short. But, you know, to go back to what Her Ladyship Justice Georgina Wood said, I mean, she said it may be classified, which meant that there are other factors that you probably have to look at to determine whether what the three things that she mentioned rise to the gravity or to the, you know.
Thank you very much, Cole. Unfortunately, time caught up with us. This is where we can withdraw the curtains. Cole Suman is in private practice, and he was in public service just not too long ago. Privileged to be the youngest lawyer to represent the President of the Republic as his counsel. He has been helping us to have a discussion about what is stated misbehavior. In 1999, in subordination to his boss, Emmanuel Jacobus Opong was removed from office as stated misbehavior as deputy chair of the NCCE. Loretta Lamte violated the rent law, which says that, you know, you shouldn't give advance in excess of 6 months and a host of things. She lost her office. Charlotte Osei, breach of procurement law alleged. She also lost her office, and many others are losing their offices on the basis of the stated misbehavior, which the Supreme Court says is nebulous and not defined. Let's continue the discussion in our homes. I'm Samson Ladia Yenini. This has been The Law. It's your legal light. It is your help law.